what we're going to do in this class, this is a contract CE class, and we are going to review the Texas Residential Lease, which is the promulgated form from the Texas Association of Realtors. TREC doesn't have a lease form, so this is the one we use. And I'll share it right now, but just to give you guys a little bit of background, this lease is very landlord friendly, which is a good thing if you're representing the landlord, because it covers them in most respects. If you're representing a tenant, I just would always have you encourage them, and this is going to sound silly, but to read the lease so that they understand what their obligations are. I have a lot of experience with this form because we have a handful of rental properties that I have managed. And so I've used this form a lot. And if you ever have questions about lease or doing leases, I know you guys don't do tons of leases. So you can get foggy on the form, just call me and we can walk through it. And if anyone has any questions, don't be shy, just blurt it out. Because I guarantee you, if you have that question, someone else also has that question. So are you guys looking at the lease form right now? And is it big enough that you can kind of see it and read it?
Yes.
Yes. Okay, perfect. Is there anyone that's like has a specific challenge of leases right now, which is why you're here, or you're all just here for CE credit, or you have just want to learn?
I just have had so many leases lately, like this summer. So I just want to make sure.
Yeah. Perfect. I love it. Anyone else? Okay, cool. So here's what we're gonna do. We're just gonna plow through this form. It's 17 pages. And we can also talk a little bit about best practices if you're representing the landlord and need to screen, but we'll go through there as we get through it. So Maria's here for the credit. She's not hoping to be having to do this anytime soon. And she knows if she ever does need to, she can just call me and I'll help her. Okay, so the parties, typically speaking, when you guys get a lease, the landlord is going to fill out this form, or the listing agent, because there's a lot of things that are like specific to the landlord and how they do business that as the tenant, like you're not going to know. If you're ever in a situation where the listing agent doesn't do leases very much and they're like, you guys write the lease, that's a little bit hard because there's a few questions that you really are for the landlord. You're not going to know. So generally speaking, the listing agent and the landlord will write the lease together. And when you take a lease listing, it asks the listing agreement itself asks a lot of these questions. So you can collect it at the time you do the listing, or once you get a prospect, you can kind of walk through the lease together with the landlord, which I think is a good thing to do because the landlords understand what's in the lease. It's $10, Michael. Good question. Okay. So, the parties are the landlord and the tenant, and generally speaking, you'll have the tenant information from the application. And I always say anyone who's over the age of 18 that's going to live in the property should be listed as a tenant, and you should also screen, right? Even if it's an adult child living with their parent, I think I would put all of them on there. If they say absolutely not, at minimum, I would screen anyone who's over the age of 18. Does that make sense? Just so you have their data, like they're an adult, even if they're a child living with their parents. And for the purposes of screening, what I do is Briggs Freeman recommends that landlords use My Smart Move. So like a sophisticated landlord is probably going to have a way that they're screening tenants themselves already. But if they're like a first-time landlord, or it's just a random one-off that they have a rental, we recommend My Smart Move. And what's great about that program is that the tenant can input their information, and it can be sent directly to the landlord. So you're not in the middle trying to like assess the quality of the tenant, because as the listing agent, you don't want to tell a landlord, yeah, this tenant looks great, and then they're terrible, right? So My Smart Move will send the information about the tenant's credit worthiness and the screen directly to the landlord, and the tenant can also pay on My Smart Move so that you're not like collecting application fees. So that's one way to do it. Now, that said, I would still have every person over the age of 18 fill out the residential lease application, because it collects a lot of good information that the landlord's going to want in the event the tenants ever default, like social security, driver's license, things like that. So I would still collect that piece of paperwork and make it part of the lease. Does that make sense? That's me being a little bit overzealous, but I think it's a great form and like information for the landlords to have. And that's just the Texas Association of Realtors residential lease application. which is, and when I do an open house, like when I list a property, I put it, and I just host an open house and tell all the tenants to come at that time. I always take copies of the application and they can take it with them and fill it out. And usually you get a couple applications and then you can decide. That's how I do it. So this is another like pro tip on actually listing a property for lease. The MLS, if you put a lease listing into MLS, it no longer syndicates to Zillow, because I think Zillow got smart and realized they can charge landlords. And also Zillow got smart and realized like, that's really where all the tenants are looking. So you need to, in addition to putting it in the MLS, if that's how you want to do it, you need to put it into Zillow, but there's a separate fee you have to pay Zillow. So I just did this not too long ago, and it's, I think it's $30 for 1 month of promotion on Zillow, and you're going to get direct tenant inquiries in there. So when you're doing your listing agreement, you may want to consider that you're going to get, 1 month's rent plus, $30 per month that is listed to cover the Zillow fee. You may just be willing to pay it, but have that discussion with your landlord, because just putting it in the MLS these days, like I think is probably a disservice to your landlord, because the tenants are all on Zillow. Questions? Good.
Yeah, I experienced that with my lease listing this summer, and I wasn't aware of that. And then once I put it on Zillow, I had like 45 inquiries in a day, and it got leased. So I realized that. Yep. But do you know anything about the property, like for a landlord? Do you know anything about that platform versus the one that we use, like apartments.com, for managing the property?
Oh yeah. Okay. So yes. So this is not like a Briggs Freeman like official, like this is what we recommend, but I use as my like property management platform, apartments.com. There's no charge as a landlord, and there's no charge to the tenant, but you can set up your leases, collect payment that will go directly into your bank account. It just keeps it all very organized. So I recommend managing properties through apartments.com. But again, that's like a Zareen tip, not a Briggs Freeman tip. Does that make sense? Is that your question?
Because Zillow charges.
Probably. Well, Zillow's not I guess you could list through apartments.com also. I've never done that. I only list through Zillow because that's where everyone is.
Right.
But once you set up once I set up one of my rental properties in apartments.com, and like the tenant moves out, I have the opportunity to promote it through apartments.com. I just never do. I just use Zillow.
Yeah. Okay.
So that's questions there, guys. Does this make sense? Okay. I promise the first all the paragraphs aren't going to take that long, but that's just some good background on like how to get your listing going and how to kind of run the listing. So, you're going to put the property, the address, what county, and then, any non-realty items. If it's a fridge, if it's a microwave, it's a washer and dryer, you list that there. And then you put your term. Typically it's at least a year, but, different situations may call for something different. This is basically says the tenant must occupy the property. And if they're not able to, because of something about the property is not ready yet, then they can terminate the lease. So that's important to know, right? You need to have the property ready on the day that the lease starts. Okay, so this is an important one, is how does a lease renew or terminate? And under this document, if a lease isn't terminated, or expressly renewed with a specific term through an amendment, which there's an amendment form also, it just goes month to month, and either party can terminate by giving written notice. And it's either 30 days before the expiration date if you check this box, or you can check this box and put something. I always put 45 days before the expiration date. And then I just have to remember, oh man, this lease is expiring at the end of October. So before September 15th, I need to check in with the tenant and see what their plan is, right? Or let them know if they want to renew, the rent is going to go up $50 or whatever it is. Does anyone have questions about that? So basically the lease is going to renew on a month-to-month basis until someone does something and gives notice. Good? Okay. So, this is the second half of that paragraph, and I get asked questions about this. If the lease automatically renews on a month-to-month, it continues until someone gives notice, right? Like we just said. And then, if the tenant gives notice, if you check this box, then it's on the last day of the month in which notice is given. So, that they have to pay the full month. If you check this, if they get notified, you say you're in a month-to-month situation and today, September 12th, they give notice, then they only have to pay through October 12th. So I always check this first box because it's just cleaner, right? They have through the end of the month, they have to pay through the end of the month. If this box is checked, it's unequivocally clear. Does that make sense?
Yeah, who wants to do math?
Who wants to do math and like prorate numbers? Exactly. Okay. So rent. So then you put, what is the amount of rent here? And then you say, obviously it's going to be due usually on the first day. And then you say, how are they going to accept payment and who are they paying? So I always check, for me, I check this box. They're going to pay the landlord. And then I say electronic payment, right? Because I have all of my tenants pay me through apartments.com. But if they want to have it paid via check, whatever, so this is why the listing agent and the landlord need to fill out this document and not the tenant, because the tenant's just guessing, right? So that's why. Questions there? Okay. And then, so this is where it gets tricky because you have to, at the beginning of the lease, you're collecting like all of these funds, right? Typically a landlord wants full first month's rent plus a security deposit, plus possibly a pet deposit, right? So if we signed a lease for September 20th, what I would tell my tenants is I want a full month's rent. I want the security deposit, and then any pet deposit that you owe, I want that also. And through apartments.com, I can send them requests for all of these amounts and they just pay it. And generally speaking, as the landlord, like I don't sign the lease until I've received those funds. So, but not all, some tenants are savvier than that and they're not going to like send funds until they have a signed lease. So, and then what I do is I would say, okay, if our lease is starting, let's say October 10th, I would collect a first full month, a security deposit, any pet deposit, and then so they'd be paid, for October. And then on November 1st, I would not charge them the first full month. I would only charge them the prorated portion of October. So they'd pay like 2/3 of a month, basically. That's how I do it. I can send you guys like a description of that math, but to me, that just makes sense. And it's very easy in apartments.com to set up like your first payment on November 1st would be this amount. And then going forward, it's a full month. Does that you don't have to do it that way. Your landlord may have an opinion on how to do it. That's how I do it because I feel like it's very clean.
So Reen, I have a question. So
Yeah.
instead of them paying October up front, you pay it at the rear?
No, you pay it up front. So essentially what they're
No,
doing
but
is
you just said if they move in October 10th and in November, you haven't paid 2/3. So you're paying in November plus the 2/3 of October?
no. So basically what they're doing is they're paying November, all of November, like up front. And then on November 1st, they're just paying for the portion of October. Does that make sense?
It totally makes sense, but I still I specifically don't do that because it does kind of get confusing to other people. It's like,
Yeah.
well, wait, but my rent is 2,500 and I'm only paying 2,000 for November for the first month. It starts out like this weird, like if most people have it on auto pay, right? So it's like, okay,
Right.
2,500 every single month, right? And so
Right.
when you do it that way, it messes up your first month of the auto pay because you've paid it, blah, blah, blah. And in my opinion, I kind of, and I know that your security deposit is not any month's rent, but how I look at it, I just do the proration and the security deposits and kind of look at it. Well, if something were to happen in that first month, I still have a first, 1 month's full rent anyway within your security deposit.
Yeah. So it just really depends on what the landlord wants, right? Like to Lori's point, it's a lot easier to say you owe me, if the rent's $1,000 and you move in October 10th, let's just say that's 2/3 a month. You owe me, $667 for October plus 1 month's rent for the security deposit, right? And then on November 1st, you'll start paying in full. You can do it that way too. It's really the landlord's preference. The way I do it, it's easily set up. And I have an email that explains it, but however the landlord wants to do it, you just have to talk to them and see. Does that make sense? Okay. All right. So then you have to say like where they're going to pay, whether if it's mailing a check, who does the check go to? Where does it go? I always just say electronic payment via apartments.com. And then I kind of prepare them that they're going to get some emails from that. So, method of payment, they must pay rent all timely and without demand. Time is of the essence. So we all know that that's like a magic term, meaning you must strictly comply with the dates. And then, how are they going to pay? I always check electronic payment, but your landlord may have different. And then do they charge a processing fee? And then this fourth one is one to pay attention to if you have roommates. whether the landlord requires or does not require the tenant to pay monthly rent by one payment. So I had in my Dallas house, I had these two guys that lived there forever and ever. And this was back when I was still taking checks, and I wanted one check, right? Because if one pays and the other doesn't pay, they're both still on the hook for the full amount. Now that I do electronic payments, it doesn't matter as long as all the money shows up, but you want to check this box, right? So if you have 4 girls sharing a house, you don't want to get 4 checks. You want them to sort it out and get one check is my recommendation, but whatever your landlord wants, right? Okay.
And
so
doing electronic payments, I'm sorry, really fast.
Yeah.
Are you doing like a Venmo or a Zelle, or are you actually putting in your banking routing, giving them routing information and all that?
Through apartments.com, the way that I do it, it just comes directly into my bank. But that's whatever makes I'm fine with that. That doesn't like concern me. If your landlord is more concerned about electronic payments, then they maybe just want to do checks. But it just goes directly into the bank account, which is clean. Okay, so if tenant fails to pay any amounts due, or if the check is not honored, landlord may require tenant to pay such amount any subsequent that you can require them to pay certified if their checks bounce all the time is basically. It also does not limit landlord from seeking other remedies if they fail to make their timely payment. So rent increases. This says there's no rent increases during the primary term, but if they do, they can provide 30 days written notice that the rent is going up next month, once you're month to month. Okay, so late charges. Then this is again where you need to ask your landlord what's your late charge policy. It has to be at least after the 3rd day. Like you can't start charging late fees after the 1st or 2nd day by law. So it has to be at least the 3rd day. I put the 3rd day in this blank, but then in apartments.com, I don't actually charge them until the 5th day because that gives them their time for their funds to show up or whatever. And then you have to decide what is your initial late charges. And it's really what your landlord think is reasonable. I put $50 for the 1st day and then $15 every day thereafter. That's what I put. It may depend on the size of the lease. It may depend on your landlord's temperature. So just ask them, but that's what I do. There. So this is the notice. The property codes prohibit assessing a late fee until it has remained and paid for at least 2 full days after the date. So that's why I put 3rd, and then I wouldn't charge them until the 5th. Does that make sense? Okay. And now this is important. For the purposes of paying rent and late charges, the mailbox is not the agent of receipt for the landlord. So there's a thing in the law called the mailbox rule, which is if you put something in the mail, the date that it's post-dated, whatever that word is the date of delivery technically, or is the date it was sent, and doesn't apply here. So the mailbox rule doesn't apply, and the parties agree that the late charge is reasonable based on uncertain damages. So the parties are agreeing here that these late charges are fair. Does that make sense? Pretty straightforward. Okay. And then, if you have a return payment for any reason, then like a bounce check fee, you put that in there. I do get a notification if like their deposit failed, and then I screenshot it and send it to them, and then they try again. That's how I do it. But you can put any amount there. Okay, applications of funds. This is underlined, so they want us to pay attention to this. Regardless of any notation on the payment, landlord may apply funds received from tenant first to non-rent obligations, including but not limited to late charges, return payment charges, repairs, brokerage fees, et cetera, et cetera, et cetera. So if you have a really bad tenant and they're behind and they also owe you money for other things that they haven't paid for, if they send you a check in the amount of the rent, this is saying you can apply that to their non-rent obligations first so that they're still in default and you can evict them if you want to. That's why this is very like landlord friendly, this lease. Does that make sense? Okay. All right, animals. This has changed recently because of so many service animals and assistance animals. And I'm going to say this right now, like we're not going to get into the like nitty gritty on animals and assistance animals. I have a really great email with some really good a really good PowerPoint and also a good website that Emily Thompson actually gave me about figuring out whether an animal is actually a service animal and actually has to be allowed. So we're not even going to get into that discussion here because we could probably talk about it for like 20 minutes. So we're just going to set that aside. But I will send you guys as a follow-up to this, like my little email about how to figure that out. But you have to agree if it's, so let's say we're talking about pets. basically you have to agree, the landlord has to agree to allow pets. Now, service animals is not a pet, so we'll set that aside. But if they do keep a pet, then you are going to have, there's a separate agreement called an animal agreement. And you're going to actually have that, whether it's a service animal or a pet, but now it's called the animal agreement. It used to be called the pet agreement. Am I making sense? Okay. All right. So if you don't have an animal agreement, you said no pets, and then you find out that they're going to have a pet, these are all the things that the landlord can do. They can, the tenant's automatically in default. They can charge the tenant as an initial amount plus an amount per day, right? And then they can remove or cause to be removed any unauthorized animal and deliver it to local authorities. Like, this is pretty intense, right? About what the landlords can do with no permission to have a pet. And then charge to the landlord, charge to the tenant any cost landlord incurs to remove the animal, exterminate the property, clean the property, repair any damage. So moral of the story is your tenants should not bring a pet without permission, because the landlord has a lot of discretion to just remove the animal. Like, can you imagine? That would be terrible. So when taking any action, the landlord is not liable for harm, injury, death, or sickness. So tenant be warned, okay? Questions about that? No. Okay. So security deposit, on or before the execution of the lease, tenant will pay a security deposit to the landlord in the amount of blank, typically 1 month's rent. How are they going to pay it? And then, security deposit is defined by the property code. The property code has extensive statutes around landlord tenant law, which is what this is drafted in accordance with. But again, we're not lawyers, so we can't interpret code or the law, but everything we're doing here is to be compliant with all of the statutes in the property code. So no interest or income will be paid to tenant on the security deposit, but landlord may place it in an interest-bearing account, and then it's interest for the landlord. And then refund. This is important. Tenant must give landlord at least 30 days written notice of surrender before landlord is obligated to account for or refund the security deposit. And any refund will be made payable to all tenants. So that's an important one. So when your tenant moves out, technically the landlord doesn't have to account for their security deposit and send it back until the tenant has given written notice of surrender to the landlord and told them where to send the funds. So that's a really important point for your tenants, okay? And for your landlords just to know. Okay, so this is bold because it's conspicuous, so they want us to pay attention to it, but this is just notices about the security deposit. And I pointed this one out to, I had one sneaky tenant one time, and he tried to say his last month's rent was a security deposit. And I'm like, nope. If you look at this section of the lease and the property code provides that a tenant may not withhold payment of any portion of the last month's rent on the grounds that the security deposit is that, right? So they can't say in the last month, I'm not paying you because you have my security deposit. You can point this out to them, because if they do, bad faith violations may subject a tenant to liability up to 3 times the rent wrongfully withheld and the landlord's reasonable attorney's fee. So that's usually scares them into paying their rent when they're supposed to in the last month. The property code does not obligate a landlord to return or account for the security deposit until they surrender the property and give the landlord a written statement of the tenant's forwarding address. So that's the law that we're talking about. How's this going, you guys? Super fun, huh? Surrender is defined in the lease that we'll get to. And then, here's the link to the property code. Super fun. So then this is a list of what can the landlord deduct from the security deposit. So they can deduct for all damages to the property except for normal wear and tear, right? And all reasonable costs associated to repair. So a normal wear and tear is things that it's just going to happen over time, and that's not necessarily the tenant's fault, but any other type of damage you can deduct for. And I'm pretty sure my husband develops apartments. I mean, I'm pretty sure that they make the tenant pay for carpet and things like that. You have to be careful about what's normal wear and tear. But what I do is then I put things into the lease specifically. I have an addendum A that I say the tenant has to do. And then if they don't, I can take it out of the security deposit. So I say the tenant has to clean the carpets or and pay for professional cleaning. So that they don't, I can automatically deduct the cost of those from the security deposit. Unpaid or accelerated rent, unpaid late charges, unpaid utility expenses, unpaid pet charges, replacing unreturned keys, security devices, etc. The removal of locks or fixtures installed by the tenant, If they leave and don't leave you the keys somewhere, you can charge them for the locksmith. The tenant's responsible for replacing bulbs, so you could charge them for that. Packing,
This is why I love, sorry, Zareen, but that's why I love the itemized security deposit when returning it, because it goes over a bunch of these different things. So when they move out, you can do this checklist and go, oh, light bulbs were out or what have you. I mean, if you want to get nitty gritty, and then you're just, security deposit starts at the top, and it's
Yeah.
itemized. It's really
And you
great.
should get nitty gritty. You can't just return half the security deposit and not say what you charged for. You have to specifically itemize, like, what were the things that your security deposit paid for, which is why I'm not returning to you. The landlord has to itemize. So that's a good point. So then, there's all these things that the landlord can charge for. So just be aware, and then if deductions exceed the security deposit, tenant will pay to landlord the excess within 10 days after landlord makes written demand. I mean, good luck, but the landlord does have the right to do that if the repairs exceed the security deposit. I've never seen that happen, but maybe. Utilities. Okay, tenant will pay all connection fees, etc., except for the following, which landlord will pay. Typically, I have the tenant pay all the utilities. Sometimes if you're have something in an HOA, you may say like homeowners association dues, right? Like typically the tenant is not paying for those, but everything else the tenant pays for, assuming that's what your landlord wants. And then unless provided by landlord, tenant must at minimum keep the following utilities on if available. So if the property has, the right power. And then this is important. Before signing the lease, tenant should determine if all necessary utilities are available to the property and are adequate. So that's just kind of puts it out there that like the internet connection, the tenant can't say, I need to move out, the internet's bad here, right? Like this paragraph covers your landlord from that situation. So it's good to know what's in this lease. I know this is painful, so thanks for hanging in there, guys. Okay. So use and occupancy, this is where you list all the occupants who are allowed to live in the property. And if you have little kids who aren't obviously tenants on the lease, like you obviously include them here. Like anyone who you say, these are the people we know are living there, so that if it's in the lease, if you ever find out that there's like 5 extra people living there, like that's a default, right? Okay. And then if they change their contact information, they have to notify the tenant. Whether it's in an HOA, you need to check and say the name of the HOA. And then also some HOAs have additional rules for tenants. We used to own a unit at the tower in Fort Worth, and they had to review the leases and approve them before we could sign a lease and let a tenant move in. And tenants had different rules than owner occupants did. So just be sure if you're renting a property that's in an HOA, like figure out what their rules are. Okay. Just something to remember. And then, of course, if there's they're in an HOA and the tenant gets fined for whatever reason, like obviously the tenant's going to reimburse the landlord. That's in there. Okay. So now this was a change. This is I forgot one thing I forgot to point out. This is the July 2022 version of the lease. They updated it. And this was one of the changes that they made. So this is things that the tenant's not allowed to do in the property. And this is important for you guys to just be aware, right? They can't do anything that's going to suspend or cancel insurance or increase premiums. And some types of dogs cause that. So you need to be aware of that. And then they can't permit any of the property to be used for, nuisance, vehicle repair, any business, right? Any activity which violates any of these rules, anything illegal, including planting, growing, consuming, or distributing pot. That was the new addition. Or any activity that obstructs, interferes with, or infringes on the rights of other people. And then they cannot put this is another change. They cannot list the property on VRBO. So that's in the lease. Good change. Questions? Okay. And then this says, tenants, obviously people are allowed to have guests, but how long? You can't have a guest that a permanent guest, right? So is it 7 days? Is it 14 days? Whatever the landlord thinks is reasonable. And then no guests are permitted to stay on the property more than twice the number of days in any 30-day period. So you can't go away for a day and then come back and start your clock ticking again, is basically what that's saying. And if it's not filled in, then 2 days total per month applies. And then, if you're in a situation where you're in an HOA and there's like common areas, but that you have to pay for, the landlord is not obligated to pay for that, right? Does that make sense? Yes. And then, this is around cars. Obviously, the worst thing is when you go and there's like 6 cars parked in front of a house, right? So tenant may not permit more than X number of vehicles. And then it says all the things that they cannot do. They cannot, permit people to store it on the lawn in front of the property, et cetera, et cetera. So just be aware that there's these parking rules in here because that can be helpful if there's ever a situation. Basically, you and your landlord, really the landlord needs to know the lease, that when the tenant pushes back about something, they can point to this specific section of the lease. And if you guys are ever stuck or in a situation, just call me, because I know it pretty well, and usually we can find what we need and like tell them to reference this paragraph. Okay, so this is important for you guys as listing agents now for sale. Access by landlord. Landlord may prominently display a for sale or for lease or similarly worded sign on the property during the term of the lease, anytime, or the renewal period. And they can take interior, exterior photographs and use the photographs online. So your tenant needs to be aware of that. If we had one recently, Allie, maybe it was with you, where the tenant really did not want photographs of their home shown like while they were living there. And so we had to modify the language. But your tenant should be aware of that the landlord has the right to come in, take pictures, and put them on the internet. So, okay, access. So before accessing the property, landlord or anyone authorized by landlord will attempt to first contact the tenant, but may enter the property at reasonable times without notice to make repairs or to show the property. So that's pretty open-ended for the landlord, right? They should attempt a first contact, but if it's reasonable, they can still enter. So just be aware of that. We modified that. It may have been the same tenant that they were like, I don't like that. So we fixed it. Actually, that was my tenant. And I was like, I'm never going to come to the property without letting you know first, but we modified it for her. And this was a month or so ago in one of my duplexes. Anyway, additionally, landlord or anyone authorized may peacefully enter at reasonable times without first attempting to contact and without notice to survey or review the property condition, right? If you think your tenant's like cooking meth or hasn't, changed the air filters or anything like that, like you can go in there at any time to make emergency repairs, to exercise a lien, to leave written notices, which you have to do when you're evicting someone, or to, seize non-exempt property if the tenant is in default. So pretty open-ended access for the landlord here. So just be aware of that, okay?
Did that change? Because I thought it was 24 hours. Didn't it used to be 24 hours access?
I don't think so. I haven't seen change to this section in a long while, but maybe.
Okay.
I don't know.
So I've had 2 leases now that wanted that revised. And so one of my like the last one I did, she's a younger girl, and she said that when she was in college, she didn't pay attention to that paragraph, and her landlord would just come in like all the time.
Mm-hmm.
And once she was in the shower, and so she just like was pretty traumatized.
Yeah.
So I looked at what you and I did the other time and talked to Angela, and had to change that again. So I've just had every one of my lease clients have a problem with that. So I just changed it to like 24-hour notice by text or phone.
Mm-hmm. Yeah,
but
if you were absolutely
landlord?
sure. I mean, this is a contract, right? So the parties can contract however they want to.
Right.
So if you have a tenant that's not comfortable with that, absolutely, we can draft some language and put it in special provisions. Please do not draft it yourself. Call me or Angela and let us write it and send it to you to stick in there. We had an agent get in trouble this year for practicing law without a license because she wrote something into special provisions that her clients dictated to her over the phone. So we had no proof. So just let us put something in writing and send it to you anytime. Okay, I'm looking at the chat. Sylvia's asking, can we use the landlord's lease form and not this Texas Association of Realtors form? Absolutely. Even when we're doing a sale, if the parties want to write a contract on a napkin and they both sign it, like that's fine. Like if they're asking us for help with the forms, we have to use the promulgated forms. But if they're sophisticated and they have their own form, absolutely, that's between the parties and you can just present it. You can't really give any advice if it's not the promulgated form. Hopefully that answers your question. But yes, Sylvia, if you have a landlord who has their own form, you just send it to the buyer's agent or to the tenant's agent or the tenant, and they can review it and figure out if they want to sign it. And then Rosemary's asking, can we get a copy of one of the residential lease agreements? Sure. And I use this addendum A. I went to a property management seminar, like literally 15 years ago. And this like old guy who managed 1 million properties, like gave us this form that he used that has like some additional like covers. And all of a sudden I've been using the same form. I haven't changed it, but it just puts like a little bit of additional burden on the tenant of like what they're supposed to do. So I will send you one.
I have a question about this because years ago we had an agent in our office who was just helping a friend. She didn't get paid on the lease at all. She just gave the form and just handed it over. And when the landlord and the tenant ended up having differences, she got tied into that lawsuit, even though she did not get any compensation or, had anything of her license. So when you're saying they can go do it on a napkin, like, where does our E&O protect us on this kind of thing? Because it was a
Well-
big deal and it cost like $60,000.
Yeah, so it's a good question. And it's kind of a good question generally, is that like anytime there's a lawsuit, whoever's bringing the lawsuit is going to probably throw the book at anyone they can. So even if you've done nothing wrong and you papered everything properly, you might get dragged into it. And that's just an unfortunate side effect of doing business, right? With respect to the forms, like if you're in Sylvia's in a situation where she has a lease listing and the landlord uses their own form, and Tessa, you brought the tenant. When Sylvia delivered that form to you, you would have to say to the tenant, this is not the promulgated form and I'm not attorney, so I can't really advise you as to the contents of this form, but please review it. And if you have any questions, like, we will put you in touch with an attorney that you can talk to, right? Or recommend an attorney for you to talk to if they have questions about it. And all you can do in that situation is paper the file properly and mind your P's and Q's, so that if you say then you did that lease and the tenant finds something in the lease once they're living there that they don't like, and then they're suing you and Sylvia and Briggs Freeman. If you papered everything properly, that's kind of all you can do, right? But we just can't give it legal advice. And if it's not one of our forms, we can't interpret it for them. So they're going to have to read it and see if they're comfortable. And if they're not comfortable, we're going to have to refer them to an attorney. Does that help? Yeah. Okay. Okie dokie. So trip charges, if you go to the property and they have their deadbolt and you can't get in, you can charge them a trip charge for whatever it costs you. And you can also just put it in the lease of like an amount they're going to pay. Because in Texas, we're going to talk about this, but there's, security device rules and fire safety rules that you have to comply with under the property code. And one of them is like a keyless deadbolt, so that a tenant can lock the door with the deadbolt and no one can come inside. We'll talk about that. Okay, so this is key boxes. So if you're listing the property, key box is a container placed on the property. It's opened by a special combination. It's a convenience, but it involves risk. This is our CYA notice. And then nobody requires the use. So that's kind of giving tenants like this is notice of what the real rules are. But then we're saying, okay, the tenant's authorizing the landlord to put a key box on the property during the last X days of the lease and at any time they list the property for sale. So you don't even need permission there. Anytime it's listed for sale, you can have a key box on it. I always put the last 45 days of the lease, but I also don't list my properties until the tenant is out, because I think it's just like a mess and it doesn't really take that long to get a property listed, usually, in my opinion. Then, if the tenant doesn't want the key box on the property, tenant may withdraw tenant's authorization, providing written notice to landlord and paying the landlord a fee of blank. I would put their 1 month's rent, because if you want to show the property in the last month and the tenant says for lease and the tenant says no, then they need to pay you a month's rent to give you like a cushion while you have to list it once they're out. Does that make sense? Or you have to go and show them all yourself, which is painful. Okay, so this references the trip charge, and then this is a good CYA for the landlord. Landlord, property manager, and landlord's broker, us, are not responsible to the tenant, their guests, their family, their occupants for any damages, injuries, or loss arising from the use of the key box unless caused by us. So we put a key box on the property to show it, and some tenant's rep goes in there and they break something, like this is protecting us. So we're not responsible. It's a little CYA. Okay, move-in condition, and this was new. Sight unseen notice. Tenant is given the opportunity to inspect the property prior to signing. A tenant who declines to do so and chooses to sign the lease does so at their own risk. They're accepting the property as is and is under no obligation to make any changes upon actually seeing the property. They're bound to all provisions of the lease. So this is really helpful if you're renting a property to someone who hasn't seen it. I personally won't do that. I've had 2 really bad experiences. The only 2 times I've ever rented a property to someone who hadn't seen the property, both of them ended in disaster. So I won't do it, but that's up to you guys. And then landlord makes no express or implied warranties as to the property's condition. Tenant has inspected the property and accepted as is, provided the landlord blank. And I usually say like, we'll mow the lawn before move-in, right? We'll get the lawn like tidy, and then it's up to them to maintain it, but we're not going to deliver it to them in bad shape. So I usually say like landlord will like, have the yard maintained one time or something like that. But anything else that the tenant may say, like, oh, are you going to put blinds in this window, or are you going to whatever? So you would put all of that in there. Okay, so then this says tenant will complete an inventory and condition form, noting any damages and deliver it to landlord within 5 days. There is an inventory and condition form you can give to your tenants that they fill out. And that way, if after the, when the security deposit comes back and the landlord took out because there was a hole in the wall, if the tenant had filled this out and said, no, that hole in the wall was there before I moved in, check out this form. It's basically, that's a tenant protection like mechanism. Most of them, when you deliver to them, don't fill it out. You can tell the tenants that are going to be really good tenants because they actually do fill it out. So if tenant fails to timely deliver it, then the property is deemed free of damages. And it's not a request for repairs. So they must direct all requests for repairs in compliance with paragraph 18. Okay, move out condition. So when the lease ends, the tenant will surrender the property in the same condition, free of all trash, et cetera, et cetera. Tenant may not abandon the property. And then these are the definitions of what normal wear and tear means, what surrender means, which is important when you have someone who just disappears, right? And then abandonment. These are important terms, and because they define what is the landlord allowed to do. Okay, and then if tenant leaves any personal property in the property after surrendering or abandoning it, then landlord can throw it away, give it away to charity. They can even sell it. And the tenant must reimburse the landlord for all costs to do so. So, questions there? No. Okay, property maintenance. A tenant's responsibility, and then this is all the things that the tenant has to do. So, on the tenant side, please make your tenant read this, right? Make your tenant read the whole list, but point this out to them. They have to keep it clean. They have to dispose of garbage. They have to change the heating and air conditioning filters. I always leave a couple where they go so that the tenants can kind of see what it is. They're in charge of replacing all light bulbs, batteries, carbon monoxide detectors, et cetera, maintaining water softener chemicals, eliminating dangerous conditions. This is an important one for us lately with all of our Sonoma-geddons. Take all necessary precautions to prevent broken water pipes. So when those things are happening, I usually text my tenants in advance and say, hey guys, just a reminder, this is where this is what you need to do. Are all tenants going to take care of it? Probably not. So the landlord may want to go do it themselves, but technically it's the tenant's responsibility. Replace lost keys, pay additional extermination costs. I've had a couple of times tenants try to get me to pay for the exterminator. So knowing that this is in here is valuable. Remove standing water, know the location of the cutoff valve, water the foundation, et cetera, et cetera. And then, so this is a lot of responsibility on the tenant, just so that your tenants are aware. And then this discusses the yard, who's maintaining the yard. The landlord can maintain it. The tenant can maintain it. Or if the landlord's I use this person, you need to contract with them. That's your option there. So your landlord just has to decide. If there's a pool or hot tub on the property, there's an addendum you need to add. And then prohibitions. If tenant installs any fixtures, et cetera, everything becomes the property of the landlord. And then this is what the tenant cannot do. More things, right? Remove any of the property, change the locks, make holes other than for pictures, permit water beds, install satellites, there's a lot of prohibitions. They can't paint, remove flooring, remove wallpaper. They can't keep hazardous materials, et cetera. So these are all the things the tenants can't do. And if they fail to comply with this paragraph, in addition to the exercising the landlord's remedies, which we're going to talk about, the landlord can do it and then charge the tenant for that amount, right? If the tenant's not taking care of the property and doing the things they're supposed to do under the lease, the landlord can do them and charge the tenant. And again, if the tenant pays rent, and that the landlord can say, okay, well, that's not rent, that you're paying me back for the things I did, and now you're short your rent. Okay, remember how that worked? Okay. Smoking, permitted or not permitted. That's an important one. And then repair requests. And you'll see this is bold, so they want you guys to pay attention to this. But, all this is important. And we only ever really read this when we get into a disagreement about what should be repaired or when should it be repaired. But you put the phone number of the person that they're supposed to call. And then, ordinarily repair to the heating and air conditioning system is not an emergency. And this is a Texas form. So, it gets 110 here, but the form says it's not, heating and air is not an emergency. So just be aware of that. we get a lot of that. I had an agent reach out recently in a temporary lease back where something didn't work for several weeks. And it's kind of like the lease back is tricky because it doesn't have a lot of these terms. So if you're ever in a situation, it's actually a good point. If you ever do a lease back that's longer than 90 days, you're not supposed to use that temporary lease back form. That's just too long of a lease to have such a flimsy document governing the relationship between the parties. And it's recommended that they sign an actual lease if it's for more than 90 days. So they should use this form. So just be aware of that, because we get a lot of strife about repairs that need to happen during temporary leasebacks. It's a tricky thing, and we need to do a better job educating both our sellers and our buyers in those situations about what their responsibilities are, but that's a whole other class. Okay, so then this is what happens when there's a condition that is not being repaired, and the property code is very, very specific. We need to be really careful about giving advice in these situations, but you would just need to read through this, is that the tenant may be entitled to like have certain things repaired if the landlord is not doing it, but do not do that without consulting an attorney, because there's no promise you're ever going to be reimbursed. So if you feel like they're taking too long to fix the air conditioning and you just call your air conditioning and person and have it fixed, do not assume you're going to get paid back, because the law here is very specific. We're not going to get into the details of this, but just be aware that the property code has a lot of details when it comes to repairs. And if you're in that situation, we'll go through and read this paragraph very specifically, and then we'll decide where to go from there. Okay. Okie dokie. Tenant may or may not repair without landlord's permission. We established that. And then all decisions will be at landlord's sole discretion. So if the AC person comes out and is like, you really need a new unit, but we can band-aid it, that's the landlord's call, right? And then this is important too. This happened to me. Like I literally landed in San Francisco and a tenant was calling on a Friday afternoon, and I was like, ugh. Landlord is not obligated to complete a repair on a day other than a business day unless required by the property code. Now that's a loaded statement, like unless required by the property code. If it's something regarding safety, maybe they are, but for the most part, you know, Monday through Friday, man, that's how it works. Okay, so payment, except as otherwise specified in the lease, landlord will pay to remedy to repair or remedy conditions if the tenant complies with the proper procedures. And this includes, but is not limited to, repairs that are not caused by tenant's negligence: heating and air conditioning system, water heaters, or water penetration from structural defects. So those are things that the landlord has to repair unless tenant's negligence caused the issue. Landlord will not pay to repair the following items unless they're caused by the landlord's negligence. And these are, you know, something that's the tenant caused: damage to doors, windows, and screens. So if the window cracks, sorry, damages from windows or doors left open, damage from wastewater stoppages, like if tenants like flushing whatever down the toilet and overflows, like that's not the landlord's responsibility. Cosmetic items, or, you know, specific appliances. Like I rented a couple of my properties, like with the TVs installed, and I put the TVs here because if the TVs broke, I was not going to buy them a new television. I would just take it down and remove it. So I put that here. So if you're renting something with like the washer and dryer as a courtesy, and then the washer dies, if you don't want to buy them a new washer or fix it, you can just say like, we're not repairing these items. Like it's a bonus until it dies, basically. Does that make sense?
Mhm.
Okay. Trip charges refers us back to that earlier paragraph. And then landlord may require advance payments for repairs for which tenant is responsible. Just good to know. Okay, so then security devices and exterior door locks. There's a lot of rules in the property code about specifically what is required physically on the property in terms of locks, safety devices, and smoke detectors. So what I do is I use a company called Mr. Rekey, and they will come out and assess the property and make sure that everything is up to, they'll change the locks, of course, and then they'll make sure that you're up to code in terms of what is required. Like sliding doors needs a pin, and everything needs a keyless deadbolt, and any exterior door needs a peephole, even if it's into the garage, which is so stupid. But there's like all these rules that you and I and landlords don't know. So I hire a third party to just keep me current, because I also feel like that's a little bit of a transfer of liability. If something bad happens, then I didn't do it, I paid someone to do it, which is at least a reasonable thing to do, right? It means I'm putting forth reasonable effort to like be compliant. So that's what I do. I'll share that Mr. Rekey, but if the landlord wants to do it themselves, they just need to be aware of what's in the property code. So then all notices or requests by tenant for rekeying and changing or installing blah, blah, blah must be in writing. installation of additional security devices by tenant must be paid by tenant in advance. We have that question sometimes where the tenant's like, I really want a Ring doorbell. And it's like, okay, well, you're paying for it. We get to choose who the contractor is. And when you go, it stays with us, is what this lease says, if we think about all the different paragraphs we've read together, right? So the tenant can do that with the permission of the landlord, but there's some strings attached, which means that the tenant pays, the landlord gets to choose who installs, and then the landlord gets to keep it. Unless, of course, you guys agree in writing otherwise.
Serene, I have a question about that. if
Yeah.
possible. I have a girl that's moving this Thursday, and we asked if she could bring her cameras, and they're not, it's on a ring. It's like something that she can like hang up, I think like by some kind of tacky tape or something like that. So we actually won't mount anything, and they're just going to be inside the house. So she could remove those and nobody would really know, right? Like we've asked him and he hasn't what?
I mean, I think the question is it a fixture? So we would have to go
Right.
back and like look at the length. If they're just taping something up, that's probably not.
Yeah. Okay.
Yeah. But if you're installing something and like screwing
Right.
it in, yeah. Good question. Okay, so here's smoke alarms. We talked about that already. I used Mr. Rike to do the smoke alarms because then I know it's like compliant and it's not on me. Okay, so liability. This is, you'll notice that this is a completely one-sided paragraph in favor of the landlord. Unless caused by landlord is not responsible to tenant for any of these items, right? That's a lot of items. And then unless prohibited by law, tenant will promptly reimburse landlord for any damages to the property caused by the tenant, their guests, or any animals, including assistance animals. So that's a big one and very one-sided. Okay, holdover. This is what happens if the tenant holds over. Rent for any holdover period is 3 times the monthly rent. This is something where the landlord has the residential lien. The landlord has a lien for unpaid rent against all their non-exempt personal property, so they can actually go in there and seize it. I would not recommend a landlord trying to do this without the advice of counsel, or if they're very sophisticated themselves. We obviously need to give no advice on how to do this because it's super complicated and just outside of the scope of what we're allowed to advise them on. We can advise them that this paragraph is here and they should read it and consult an attorney, but that's pretty much what we should do. Okay. This subordination just says that the lease and the tenant's interest are subordinate to any mortgage that you have on the property. Casualty loss. This refers you to the section of the property code that kind of governs the rights of it. But proceeds for casualty loss are the landlord's sole property. Of course, your tenant needs renter's insurance to protect their personal property that's inside the home, right? And then special provisions, don't write anything in here unless me or Angela send it to you, please. Okay, so default. If the landlord fails to comply, tenant may seek any relief provided by law. Good luck, tenant, right? Like figure it out on your own. If the tenant fails to timely pay all amounts due or otherwise fails to comply with the lease, tenant will be in default and then this clearly lays out all the things that the landlord has the right to do. So again, very one-sided document. I'm not saying that to make you guys paranoid. I'm just saying that to like help your landlord clients sleep better and to make sure that you advise your tenants in writing to read the lease, right? So that they can't get mad at you, to Tessa's point, if there's something in there that they don't like. If you have an email that says, I advise you, please read through every paragraph of this lease and ask me if you have any questions. That's a good email to like save to the file. Okay, so this is important. Landlord will attempt to mitigate any damage or loss caused by tenant's breach by attempting to relet the property to acceptable tenants and reducing tenant's liability accordingly. So if the tenant moves out early or vacates out early, technically they still owe us under the lease through the term, but the landlord does have a duty to mitigate and try to get it released. So that's important. That's actually in favor of the tenant. Okay, early termination. This is very specific. There are very, very narrow examples of when a tenant is allowed to terminate early. It's not if you get transferred for your job. It's not unless your job is in the military. It's very specific situations that the tenant has the right to terminate early. And if it relates to military, violence and or sex offenses or stalking. So this gets very specific. If you feel like you're in one of these situations, reach out to me and we can help. Okay, assignment or subletting. They're not allowed to assign the lease or sublet it. We've already established they can't do VRBO. If they want to terminate early, they can attempt to find a replacement tenant. Then any assignee or subtenant must be acceptable. So they have to be approved, all of the things, sign a new lease or sign a sublease or an assignment of lease. And then who's paying commissions? Because if you have to release it 7 months into the lease, like that's the same amount of work for you. So you can say the tenant's going to pay like a fee depending on who finds it. Of course, a lot of times our agents feel bad if they put a tenant, help find a tenant, and then the tenant vacates, and so they'll do the work for free. But if you put this in the lease, technically you shouldn't have to. Okay, this is just regarding attorney's fees, prevailing party wins, representations. Again, a totally one-sided statement here. Tenant statement in this lease and in the application or material representations. They're of legal age. Any misrepresentation is a default. And then here's where you check all of your addendum. I have, like I say, I have addendum A. I always check to include the residential lease application so that this become part of the document. If there's a, agreement between brokers, if there's a situation where the tenant buys from the landlord, then you may earn a commission if that's what's in the agreement between brokers. So you just need to check these boxes to say that they're incorporated into the lease. And then where are they sending notices? This is important to pay attention to. You can always send a copy to the tenant at the property, but usually you want the tenant's emails in there so you can email it as well. And then for legal notice purposes, you have to do all of these things, just like in our sale contract. And then you have to give the landlord's address for the purposes of legal notice. Okay, 3 minutes left and we are almost at the end. So, these are just boilerplate documents. This one says joint and several. So all tenants are jointly and several liable. If there's two, like I said, I had those two guys that were roommates. They were both responsible for the full amount. That's what that means. So this is saying landlord's past delay does not mean that they can continue that going forward. This is all pretty boilerplate language. If an active realtor member or Texas realtor does not negotiate this lease, the lease is voidable at will by the tenant. So that protects the tenant from a landlord just using this form without an agent involved. Okay, just good to know. Okay, so now more information. Total sidebar. I just want to make sure before you guys go that I have everyone. I have Michael, Lori, Rosemary, Sylvia, Kathy, Allie, Maria, Tessa, and Jana. If anyone else wants CE credit and I didn't say your name, please put your name and license number in the chat. Okay, I see one more. Madison. All right, perfect. Okay, so then, it's tenants, these are important points to know. It's tenants' responsibility to determine before signing the lease that everything is good. That's just repeating something we've already said. This is saying the brokers have no knowledge about whether landlord is delinquent, right? If the landlord gets foreclosed on while the tenant's in play, there's all sorts of laws around that and tenants' rights. Hi, Jenna, I got you. Okay. Then any amount is reportable to, any unpaid amount is reportable to credit reporting agencies. Landlord is not obligated to respond to any requests for tenant's rent payment history. So if the landlord doesn't have to answer if the tenant's like applying for a mortgage about how they're doing. This the tenant needs to fill out if they die, who is allowed to enter the property and get their belongings. And then
So Zareen, if somebody, say you have a tenant that passes away in the property, there's nothing in the nothing in the contract that says anything about the rest of the rent. I mean, I know that would be a very, very sad situation, but you just list your, next of kin there and that's it.
Yeah, that's what this paragraph G actually covers. If a tenant who is the sole occupant of the property dies before the expiration of the lease, a representative of the estate or the person named here may terminate the tenant's rights and obligations if the representative provides the landlord written notice of termination as required by the property code and the deceased tenant's property is removed from the lease premises in accordance with the property code, et cetera, et cetera, et cetera. So that this happens in that situation. Now, if I were in the situation where I had those two guy roommates, if one of them died, then the other one is still responsible fully under the lease. But if it's a sole occupant that dies or everybody dies, this is basically governs that situation. Paragraph G. Okay. And then this is a little CYA for us saying that the DPS has a database. If you guys need to go for it. Amy, I see you. Michael, Adriana, I see you. I got you guys, because it's 10 o'clock. I don't want to keep you, but we'll just finish. We have one more page. This is helpful. This is a CYA for us about, and if your tenant is reading it, this is kind of helpful to them that they could look up. We're not responsible for disclosing that as the listing agent. Okay, this is saying where they need to get rental insurance and that they're not covered by our property insurance. And this says, who's the property manager? Again, at Briggs Freeman, we don't manage properties. It's a whole other ball of wax and liabilities that we don't have insurance coverage for properly. And I just don't recommend it. It's also like super painful to do. So we can always refer to a property manager. And then that's all we have. Hopefully the landlord signing this and the tenant signing this, right? Unless we're the written property manager, we do not sign this, right? So even though it says broker associates, but we don't have written property management agreement or power of attorney. So it's always going to be the landlord and the tenant. Okay, 10:01, we did it. Any questions? Whew.
Zurian, can you hear me?
Yeah.
Okay. I know we weren't really going to talk about it, but I just kind of have one question. So on the service animal thing, if a landlord does not want pets, does not want any animals in there at all, and then, because this did happen with a client, but and then someone with a service animal, comes forward and wants to lease the property, is there any can the landlord just not return phone call? I mean, do they have to rent to them? I mean,
yes.
they
Under
just
fair
have to rent
housing
to them.
requirements, like the landlord is required to make a reasonable accommodation. I mean, there are exceptions when the landlord is not required, but generally speaking, the landlord does need to make a reasonable accommodation. So it just
Isn't
depends.
that
on
a
what
fair
accommodation you're
housing?
looking for.
Isn't that a fair housing law?
Yeah, it's fair housing.
Well,
But
I know, but
wait, I thought there was no fair housing in leases. Like you can decide you just don't like them and not have them rent. I thought that was the opposite.
No, in fact, let me show you guys something. We have something called the tenant selection criteria that said there is fair housing, that you can't discriminate. So let me pull it up.
I mean, if their credit is bad, then you can
Yeah,
disqualify.
and that's what this tenant selection criteria, I'm glad you brought that up because it's an
Yeah.
important document.
You can find another reason, but you can't do it because of a.
This is in
service.
BF Office. Where did it go? I have like 1 million windows open.
Yeah, I was told if you don't want a tenant with kids, if you don't like their age, you can say no.
I mean, maybe you don't. I mean, you wouldn't say why, but
Right. You don't say why, but they get to decide who they want living in their property.
So generally speaking, let me share this. This is a document you should deliver with, and I put this as the 5th page when I deliver the residential lease application that says these are the criteria under which we're going to review you and the things that we may not approve you for. And so these are the reasons, and these are all like fair housing compliant, but you can't say like, I don't want a family to live here.
Right.
It's a protected class, familial status. So
That was
if you're
my
going to
learning
leave,
today.
this is a document I encourage you because it gives you, if you reject someone, you're giving them the reason for the rejections like in advance. These are the criteria which we're going to review you on, and that keeps you like fair housing compliant.
so you couldn't just not return the call.
Well,
I'm jumping off, Sylvia, but
Okay.
if someone
don't return the call.
submits a written application, you don't necessarily have to screen them. Like sometimes I get 4 applications at a time and I'm like, this one looks like the best.
Yeah.
And I'm looking at income. That's what I really care about. And then I'll just screen one of them and I let the other people know. And I don't make the other people pay me the application fee until I know I am in fact going to screen them and like spend the money.
Okay.
So does that help?
Yes. Yes. Thank you.
Okay.
Thanks for the class.
No
Yes.
problem. Thanks for hanging in there, guys. I know this is like, not fun. If you ever have questions, just call me. Okay.
Thank you.
Bye guys. Thanks so much.
Okay, bye.